Indiana has a landlord-friendly breaking lease framework with minimal state-level regulation and strong preemption provisions that prevent local governments from adding requirements. The governing law includes Indiana's landlord-tenant statutes, found in Indiana Code Title 32, Article 31, along with general contract principles. If you're a landlord or tenant in Indiana, the state gives landlords broad discretion while recognizing the basic duty to mitigate. Let's start with the landlord's duty to mitigate damages. Indiana law recognizes the landlord's duty to mitigate when a tenant breaks a lease and vacates. This duty is established through Indiana case law, most notably the Indiana Court of Appeals decisions that have confirmed landlords cannot simply sit idle and collect the full remaining rent. The landlord must make reasonable efforts to re-rent the unit. The landlord must take reasonable steps, advertising, showing the property, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced. Indiana's mitigation duty is based on case law rather than a detailed statute, which means courts evaluate reasonableness on a case-by-case basis. The local market conditions, the property's condition and location, and the landlord's typical practices all factor into the analysis. Indiana's preemption statute, Section 32, 31, 1-20, limits local governments from regulating certain aspects of the landlord-tenant relationship. This preemption ensures statewide uniformity in the breaking lease framework. No Indiana municipality has enacted local provisions that add requirements beyond state law. Indianapolis, Fort Wayne, Bloomington, and every other Indiana community operate under the same framework. Early termination clauses are generally enforceable in Indiana. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. Indiana courts enforce reasonable contractual provisions. The fee must represent a reasonable estimate of anticipated damages rather than a grossly disproportionate penalty. Many Indiana landlords include a reletting fee provision, covering the landlord's specific costs of finding a replacement tenant, in addition to or instead of a flat early termination fee. Reletting fees that cover advertising, showing, and application processing costs are generally enforceable. Military members have the right to break a lease under the SCRA. Indiana's military population is moderate. Naval Support Activity Crane, commonly called Crane Naval Weapons Center, in southern Indiana generates some rental demand in the Bedford and Bloomington areas. Camp Atterbury near Edinburgh is primarily a National Guard training facility. Grissom Air Reserve Base near Peru has limited active duty demand. Any service member renting in Indiana has full SCRA protections. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Indiana has enacted protections for victims of domestic violence and sexual assault that allow early lease termination. Under Indiana Code Section 32-31-9, a tenant who is a victim of domestic violence, sexual assault, or stalking, or whose dependent child is a victim, can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid protective order or a copy of a police report or incident report documenting the domestic violence, sexual assault, or stalking. The tenant must provide written notice. The statute specifies the requirements for the notice period and content. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules, returned within 45 days. Indiana's provision includes an important protection for the tenant's safety. The landlord must allow the victim to have the locks changed on the unit, at the tenant's expense, if the perpetrator had access. The landlord must keep the documentation confidential and cannot disclose the tenant's status as a victim. Tenants in Indiana may break a lease if the landlord fails to maintain habitable conditions. Indiana recognizes an implied warranty of habitability. Under Indiana Code Section 3231.85, the landlord has a duty to maintain the premises in a condition that is safe, clean, and fit for habitation. If the landlord fails to address serious deficiencies after receiving written notice, the tenant has remedies that can include lease termination. The tenant must provide written notice to the landlord identifying the specific deficiency and allow a reasonable time for repair. Indiana does not specify a precise statutory repair period like some states. The standard is reasonableness based on the nature and severity of the issue. If the landlord fails to act within a reasonable time, the tenant may terminate. Indiana also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, changing locks without authorization, failing to address dangerous conditions, render the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time. Indiana has specific provisions regarding abandonment. Under Indiana Code Section 3231.5, if a tenant abandons the property, the landlord can retake possession. The landlord should document evidence of abandonment, unpaid rent, absence from the property, removal of personal belongings, disconnected utilities, before entering and re-renting. The departing tenant remains liable for damages subject to the mitigation duty. Indiana also has specific provisions regarding the tenant's personal property left behind after abandonment. The landlord must follow proper procedures for handling abandoned property, including providing notice to the tenant and allowing a reasonable period for retrieval before disposing of the items. From a practical standpoint, Indiana has a large rental market concentrated in several major metros, with secondary markets across the state. Indianapolis is Indiana's dominant market. The economy is driven by healthcare, pharmaceuticals, Eli Lilly, logistics, technology, motorsports, and government. When a tenant breaks a lease in Indianapolis, re-rental times vary by neighborhood. Downtown, Mass Ave, Fountain Square, and Broad Ripple have strong demand, typically 2 to 4 weeks for re-rental. Carmel, Fishers, and Noblesville in the northern suburbs attract families and fill quickly. More outlying areas take longer. Indianapolis operates under state law. The preemption prevents local additions. But Indianapolis's local fairness ordinance protecting sexual orientation and gender identity affects screening of replacement tenants. Fort Wayne has a moderate market driven by manufacturing, healthcare, and defense. Re-rental is moderate. Fort Wayne's growing immigrant and refugee community, including Burmese and Hispanic populations, adds diversity to the tenant pool. South Bend, home to Notre Dame, has a moderate market. Evansville has a moderate market in southwestern Indiana. Bloomington, home to Indiana University, has one of the tightest markets in the state relative to its size. IU's massive enrollment creates enormous student demand. Lease breaks during spring and summer fill rapidly. Mid-semester breaks take longer. West Lafayette, home to Purdue University, has a similar student-driven dynamic. Purdue's large engineering and technology programs attract students from around the world, and international students who break leases may be returning to their home countries, making damage collection impractical. Gary, Hammond, and Northwest Indiana communities in the Chicago metro have markets influenced by proximity to Chicago. The steel and logistics industries drive local employment. Gary has experienced population decline with softer markets. Terre Haute, Muncie, and Anderson have moderate to soft markets. Landlords in these communities should set realistic expectations about re-rental timelines. One best practice for Indiana landlords: include a clear early termination clause in your lease. Indiana's preemption ensures statewide uniformity, so you can use the same clause across all your Indiana properties. Specify the notice period, the fee, and the process. A well-drafted clause gives tenants a clear path and encourages communication rather than abandonment. Another best practice: begin re-rental efforts immediately and document every step. Indiana's case law-based mitigation duty means your documentation proves reasonableness. Keep records of listing dates, advertising channels, inquiry counts, showings, and when you accepted a replacement tenant. A third best practice, have a standard process for handling domestic violence terminations under Section 32(31)(9). Accept the documentation, process the termination, allow lock changes, return the deposit within 45 days, and maintain confidentiality. Training your staff on this process ensures compliance. Indiana does not have a statutory cap on security deposits. The deposit amount is governed by the lease. The deposit must be returned within 45 days of the tenant vacating with an itemized statement of deductions. These rules apply to broken leases and normal move-outs alike. For the complete guide to Indiana breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.